presiding. Please be seated and come to order. At this time, we'd ask that you please turn off all electronic devices. There is absolutely no food allowed in the courtroom. Water is permitted. We'd like to leave the courtroom in the same condition we found it earlier this evening. The court thanks you for your cooperation.
All right. Good evening, everybody. My name is Judge George Beer, as the bailiff has just indicated. I'm a judge here at the Superior Court in San Mateo County. I've been a judge here for 19 years now. I sit in the probate department these days, but I've tried virtually every kind of case that we try here in San Mateo County, so I do have quite a bit of trial experience over my career's duration. I was a district attorney, deputy district attorney before that, and deputy county counsel here in this same county. So with that, we're ready to proceed with the trial. Clerk has introductions, as I understand it.
Yes, Your Honor, the prosecution has introductions.
Thank you.
Good evening, Your Honor. My name is Andy Parker, P-A-R-K-E-R, pretrial counsel for the people. At this time, Your Honor, may my co-counsel please introduce themselves?
Yes, Ms. Parker.
Good evening, Your Honor. My name is Catherine Hurd, H-U-R-D, counsel for the people.
Good evening, Your Honor. My name is Kate Park, P-A-R-K, counsel for the people.
Good evening, Your Honor. My name is Shaina Ahuja, A-H-U-J-A, counsel for the people. At this time, Your Honor, may our witnesses please introduce themselves?
Yes.
Good evening, Your Honor. My name is Colton Conley, C-O-N-L-E-Y, and tonight I am Dr. Ricky Sanchez.
Good evening, Your Honor. My name is Mackenzie Bressie, B-R-E-S-S-I-E, and tonight I am Riley McAllister.
Good evening, Your Honor. My name is Chris Crouch, C-R-O-U-C-H, and tonight I am Officer Robin Doherty.
Good evening, Your Honor. My name is Mira Kumar, K-U-M-A-R, and tonight I am Alex Weaver. At this time, Your Honor, may our clerk please introduce herself?
Yes.
Good evening, Your Honor. My name is Jamie Redmond, R-E-D-M-A-N, and tonight I am your clerk. I will be giving both visual and auditory time signals at 2 minutes, 1 minute, 30 seconds, and time. Thank you.
Good evening, Your Honor. My name is Joseph Kaiser, K-A-I-S-E-R, and tonight I will be arguing the pretrial motion on behalf of Mr. Concha. At this time, may our trial attorneys please introduce themselves?
Yes.
Good evening, Your Honor. My name is Grant Hillier, H-I-L-L-Y-E-R, and I'll be representing Mr. Concha.
Good evening, Your Honor. My name is Peter Campana, C-A-M-P-A-N-A. I will be representing Mr. Concha.
Good evening, Your Honor. My name is Will Summerlin, and tonight I will be representing Mr. Concha. At this time, may our witnesses please introduce themselves?
Please.
Thank you.
Good evening, Your Honor. My name is Joel Flores, F-L-O-R-E-S, and tonight I'll be Dr. Brooke.
Good evening, Your Honor. My name is Sam Sorkin, S-O-R-K-I-N, and tonight I'm Avery Perkins.
Good evening, Your Honor. My name is Andrew Garcia, G-A-R-C-I-A, and tonight I'm Dale Piper.
Good evening, Your Honor. My name is Carmen Stacy, S-T-A-C-Y, and tonight I am Ray Concha. At this time, may our bailiff please introduce himself?
Good evening, Your Honor. My name is Max Chapman, C-H-A-P-M-A-N. Tonight, I'll be your bailiff. At this time, may our unofficial timer please introduce himself.
Good evening, Your Honor. My name is Thomas Kish, K-I-S-H. Tonight, I'm your unofficial timer.
We have an incorrect name on our defense team list for Dr. Burke.
Yeah. Yes.
I just wanted to double check. We didn't catch the name of the student who's actually playing the part.
F-L-O-R-E-S.
Flores. Okay. And what's his first name?
Joel.
J-O-E-L.
Joel Flores. Thank you. So thank you.
Thank you. An additional reminder, if you've brought a cell phone with you to court today, please silence it before we start, as I'm about to do with mine. There's nothing more annoying than a cell phone going off in the lower court. Ready to proceed?
Yes, Your Honor.
We begin with the motion practice of this case. I understand there's a defense motion.
Yes, Your Honor.
You may proceed.
Your Honor, the defense respectfully requests that you suppress the portions of Ray Conch's and Officer Doherty's testimony regarding the officer's search of my client's car in the supermarket parking lot. The officer's search violated my client's Fourth Amendment rights, and therefore the evidence and testimony regarding that search should be inadmissible in this court. On the night of February 22nd, Officer Doherty performed an unreasonable search of my client's car. The officer approached the car, and since he couldn't see the contents inside, even after using a flashlight and peeking through a slightly open window, he hoisted himself on the hood of the car. In order to do this, he stepped on the front passenger side tire and shone the flashlight through the windshield. The officer saw a jacket placed on top of a backpack containing a roll of bills, a generic prescription bottle, a plastic bag of pills, and a notebook. However, the officer's means of viewing these items was illegal because it was indeed a search and the officer had no warrant. Mr. Concha had a reasonable expectation of privacy of his own car and its contents. He had a dark tint on all his windows to prevent anyone from seeing inside, and purposely draped a jacket over his belongings to prevent anyone from seeing them. In the case of Katz versus United States, Justice Harlan introduced a two-part test to determine if a person had a reasonable expectation of privacy and if the property is protected by the Fourth Amendment. The first is based on subjectivity. Does this person intend his or her belongings to be private? The second is based on objectivity. Would society accept this person's intentions of privacy as reasonable? Katz also established that physical intrusion was not necessary for an officer's actions to constitute a search. Furthermore, Officer Doherty's use of a flashlight to look inside my client's car was a search. In the case of Kylo versus United States, the court ruled that the police's use of a device to see inside of a suspect's house was unconstitutional. In the case at hand—
But it wasn't a flashlight in that case, was it?
No, Your Honor.
How do you square your position with Texas versus Brown?
Well, the facts of Texas versus Brown, which state that the use of a flashlight in this situation would be reasonable, the facts of that case are markedly different from the facts of our case because Brown was performed at a traffic stop, not in a public place like a parking lot, and the officer had a legal vantage point in Brown, rather than our case, in which the officer had to climb all over Mr. Concha's property to see the items.
Proceed.
Thank you, Your Honor. In our case, Officer Doherty also used a device to get a better view inside my client's SUV. The use of the flashlight allowed him to see what would have been invisible otherwise. Officer Doherty's search was illegal because the items he saw were not in plain view. The case of Horton versus California introduced a three-part test to determine if an item was in plain view and exempted from the warrant requirement. The first, was the officer lawfully present from where he could see the items? 2, did the officer have a lawful right of access to the object? And 3, was the nature of the object readily incriminating? Mr. Concha's items were not in plain view because they failed to pass that three-part test. Officer Doherty was not lawfully present on the hood of my client's car. He had to climb all over my client's property, which is trespassing. Mr. Concha's items were not incriminating either. The pills the officer saw were Mr. Concha's valid prescription medication, and the roll of money and notebook came from his band's CD and t-shirt sales. Furthermore, in the BRK matter, the court determined that since there were no exigent circumstances for the deputies to approach and investigate an otherwise dark and quiet house, they should have gotten a warrant in order to proceed with searching that house. This parallels my client's case because his property was also dark, unassuming, and lacking any indication that there was anything illegal residing within. Even in the existence of probable cause, there were no exigent circumstances for the search, so the officer should have gotten a warrant. Your Honor, the defense asked the grant for motion because Officer Doherty did indeed violate Mr. Concha's Fourth Amendment constitutional rights, and the testimony regarding that search should be inadmissible in this court. Thank you, Your Honor.
Thank you.
Once again, Your Honor, my name is Andy Parker. May I proceed?
Please.
The defendant's motion to suppress should be denied because the defendant had no reasonable expectation of privacy. Even if he did, Officer Doherty's actions fell under the plain view exception to the warrant requirement. For these two reasons, Mr. Concha's Fourth Amendment rights were not violated, and the evidence is admissible. The relevant facts here are simple. In a public parking lot, Officer Doherty recognized the defendant's car and noticed that one of the windows was rolled down a few inches. He looked inside, and then, to get a better view of the interior, he stepped onto the tire and leaned over the hood, a position from which he could see evidence on the center of the back seat. Now, we agree with the defense that the standard to determine whether Fourth Amendment protections apply at all is the two-part inquiry established in Katz v. United States, 1967. First, was there an expectation of privacy? Second, was that expectation reasonable? Let's start with that first part. Did the defendant show an actual subjective expectation of privacy? Well, the defendant left the side window partially open, didn't even fully cover the pills and money, and left those items on the center of the rear seat, visible through the front windshield. Your Honor, there was no actual expectation of privacy. However, even if Your Honor finds that there was, any such expectation was unreasonable, and therefore fails the second part of the Katz inquiry. When discussing reasonableness, opposing counsel discussed what Officer Doherty did and how he crawled onto the car. But under the Katz test, when determining whether a defendant's expectation of privacy is reasonable, we do not focus on what the officer actually did in this case. Rather, as the Supreme Court established in Texas v. Brown, the question we ask is, could an inquisitive passerby or diligent police officer have seen this evidence in any reasonable way? And the answer in this case is yes. An inquisitive passerby could have seen this evidence sitting in a larger car parked in front of the defendant's vehicle. Diligent police officer could have stood on a stool or a box, even a shopping cart, and seen through the front windshield.
But that's not what happened here, is it?
No, Your Honor, but the Katz test does not ask what actually happened here. It's used for determining whether there's a reasonable expectation of privacy. And when we're analyzing that issue, we don't look at what the officer actually did. We look at whether the defendant's fundamental expectation was reasonable in the first place. Have I answered Your Honor's question?
All the windows are tinted, other than the windshield, isn't that right?
Yes, Your Honor, but the defendant left one of the side windows rolled down. Furthermore, Your Honor, this evidence could be seen through the clear front windshield.
Proceed.
Yes, Your Honor. Given that any number of ways this evidence could have been reasonably viewed, any expectation that these items visible through the front windshield would remain private was simply unreasonable, and Fourth Amendment protections do not apply. However, even if Your Honor finds that both parts of the Katz test are satisfied and Fourth Amendment protections apply, this evidence is still admissible under the plain view exception. Opposing counsel stated that plain view is defined by Horn v. California. However, that is a three-part test with relation to seizure. In this case, we're dealing with whether there was a reasonable search. And when looking at whether there is a reasonable search, the only criteria for plain view, as established in the first part of Horton and upheld in People v. Rogers, is whether the officer was lawfully present. Opposing counsel presented you with no case law to suggest that Officer Doherty was unlawfully present on the tire of the defendant's car. In fact, in United States v. Dunn, the Supreme Court held that evidence seen by officers standing on private property after having jumped over a fence was in plain view. Because Officer Doherty stayed outside the defendant's vehicle, use of a flashlight is not constitutionally significant, as held in Texas v. Brown and People v. Rogers, and there's no general bar against merely standing on private property to look for evidence, the plain view exception applies.
How do you justify your position with his position on the hood of the car?
Your Honor, there's no case law to suggest that an officer cannot stand on the tire of a car. In fact, as I mentioned, Your Honor, in United States v. Dunn, the court held that merely standing on private property does not necessarily mean that there has been a trespass under the meaning of the Fourth Amendment. Have I answered Your Honor's question?
Okay.
Your Honor, there is no reasonable expectation of privacy under the Katz test, and even if there was, the plain view exception applies. For these two reasons, Mr. Concha's Fourth Amendment rights were not violated, and the evidence is admissible. Thank you.
Your Honor, the prosecution has made an attempt to prove that Officer Doherty's actions did not constitute a search. However, The fact that the officer had to continually search my client's property for incriminating evidence, even after failing to do so once, suggests that the officer's actions were indeed unreasonable. Your Honor, two things happened that night. The first was when the officer approached my client's SUV and nearly peeked through the window of the car and saw only a jacket and a backpack, nothing that would indicate the presence of contraband. Excuse me. Yet the officer went further to perform a full-blown search by hoisting himself on the hood of my client's car and shining a flashlight through the windshield. This was a clear invasion of my client's privacy and, in fact, an illegal vantage point, thus invalidating the plain view exception of the item seen. Furthermore, the prosecution cites Texas versus Brown, which rules that the police's use of a flashlight to see inside a suspect's car was not unreasonable. However, the facts of Brown differ markedly from the facts of our case at hand, because Brown was performed at a traffic stop rather than a public parking lot.
Why should that make a difference?
Well, Your Honor, in Brown, the officer was actually lawfully present by the side of the suspect's car rather than on top of the hood. And in addition, in Brown, the occupant of the vehicle was actually inside of the vehicle, not off somewhere else. And they voluntarily rolled down their own window, thus giving the police a valid reason to look inside the car rather than just simple suspicion.
Okay, proceed.
In addition, the case of Kylo versus United States rules that the use of a device to see inside of a suspect's house was unconstitutional. In regards to the case at hand, use of any device, therefore, should also be considered unreasonable to see something that would be invisible otherwise. Your Honor, the defense respectfully requests that you grant our motion, because Officer Doherty clearly violated my client's Fourth Amendment rights. And the evidence and testimony regarding that
30
case,
seconds.
regarding that search, should be inadmissible. Thank you, Your Honor.
Thank you.
May I proceed, Your Honor?
You may.
Your Honor, there are three things I'd like to discuss. First, opposing counsel focused on the fact that Officer Doherty didn't see anything especially suspicious when he first looked into the car. But Your Honor, the defendant had no reasonable expectation of privacy, and the plain view exception applied. And if either of those cases are true, then whether the officer had any sort of suspicions is not relevant. The officer only needs suspicions and probable cause if he was to conduct an unreasonable search and wanted to procure a warrant. Second, Your Honor, with the issue of plain view, opposing counsel still provide no case law to suggest why it is illegal for an officer to stand on a car when looking through the front windshield. As I mentioned earlier, Your Honor, United States v. Dunn clearly states that not all private property is intrinsically protected under the Fourth Amendment from police officers merely standing on it to look for evidence. In fact, Your Honor, that's a privilege that United States v. Dunn reserves for the home and its curtilage. The third issue I'd like to address, Your Honor, is the issue of the flashlight.
1 minute.
Opposing counsel once again said that the flashlight was a relevant factor in this case. But Texas v. Brown clearly states that the light provided by a flashlight can have no constitutional significance. That's irrelevant of the specific facts in Texas v. Brown. And that's the same standard, Your Honor, held up in People v. Rogers when the court found that the light from the flashlight in that case was not a relevant factor. Opposing counsel compared the light from the flashlight to the thermal imaging device in Kylo v. United States.
30
But that's
seconds.
entirely distinguishable because in Kylo v. United States, the court held that there was an unreasonable search because the thermal imaging device is not generally available to the public and you have a reasonable expectation of privacy in the home more so than a car. Once again, Your Honor, there was no reasonable expectation of privacy, and even if there was, the plain view exception applied. This evidence is admissible. Thank you.
Thank you, counsel. I assume the matter is submitted, is that right?
Yes, Your Honor.
Based on the evidence or the arguments that I've heard today, and the evidence as I understand it from the factual description contained in the problem of the case of People versus Concha, I find the logic of the Texas versus Brown case to be compelling and frankly convincing with regard to the facts of this case. Although there are factual differences in this case, I find that those are distinctions without a material difference. Consequently, Texas versus Brown being controlling, the motion is denied. Ready for trial?
Yes, Your Honor. At this time, Your Honor, may the people please rearrange their seating.
And likewise with the defense.
Thank you, Your Honor.
Yes, Your Honor.
You may do so.
Your Honor, before the people begin with opening statements, may we address a few preliminary matters? First, while Rule 3.1D in the mock trial rulebook makes it clear that stipulations are already admitted into evidence, we ask that the charges be considered part of the record as well, but that their reading be waived.
No objection, Your Honor.
So ordered.
Your Honor, the people would ask permission to enter the well during opening and closings as well as direct and cross-examinations.
And I grant permission for all counsel to enter the well during the examinations.
Yes, Your Honor. The people have brought two exhibits with us here today that have been shown to and approved by defense counsel, and we ask that they be marked as Exhibit A and B for identification purposes.
We do not object on that ground, on those grounds, but we do object, they may not be entered into evidence without foundation, and so we do not object to that. However, we do object that they're admitted into evidence.
Your Honor, we will lay the proper foundation during Officer Doherty's testimony.
Subject to the laying of appropriate foundation, the exhibits will be admitted.
Yes, Your Honor. And finally, we'd like the court to note the most recent errata issued October 23rd, 2013, and we have a copy if you'd like one right now.
I think I have one here.
Yes, Your Honor. With that, the people are ready to proceed.
You may do so.
Once again, for scoring purposes, my name is Catherine Hurd. May I proceed?
Please.
On March 27th, 2013, Jason Johnson, a high school senior, collapsed. His heart stopped. He died. His cause of death? You will learn it was a cardiac arrhythmia triggered by Adderall. The defendant in this case, Ray Concha, has been charged with the selling of amphetamines in second-degree murder. Your Honor, tonight, the people ask you to listen for three specific things. One, the defendant sold Jason Johnson Adderall, a prescription amphetamine. Two, the defendant knew that selling Jason Johnson Adderall was dangerous to his health. And three, that Adderall was the main cause of Jason Johnson's death. These three facts will become clear through testimony from medical experts, the police investigating officer in this case, as well as teachers and students from Rosewood High School, who knew both the victim and the defendant. In the days and weeks leading up to Jason Johnson's death, you will learn that the defendant was under investigation by an undercover officer, Officer Doherty, for the selling of drugs at his own high school. You will learn that the defendant asked Officer Doherty, who was undercover as a high school student, Sam Shumway, "You interested in that stuff? I have a hookup for Adderall." Officer Doherty also found pills in the defendant's car, and these pills were neatly organized into plastic bags of 5 pills per bag. A number that you will learn is significant because the defendant's daily dose is only 3 pills per day. Alex Weaver, a student at Rosewood High School and a friend of both the victims and the defendants, will describe to you what she perceived to be a drug deal between the two only one day before Jason Johnson's death. Alex will tell you that only hours before Jason Johnson's death, she saw the defendant hand him something by means of a handshake. Officer Doherty will tell you that handshakes are used by drug dealers to exchange drugs. Dr. Ricky Sanchez, Chief Medical Coroner of Rosewood County, will explain to you the cause of Jason Johnson's death. A cardiac arrhythmia caused by Adderall. Dr. Sanchez will describe Jason's heart condition, a condition worsened by amphetamines, made so much worse that it resulted in Jason Johnson's death. Under the law, if the defendant sold Jason Johnson Adderall, knew that selling Jason Johnson Adderall put him at risk, and disregarded that risk, he is guilty of both charges. Tonight, the people will prove those elements.
the end of this trial, my co-counsel, Miss Park, will ask you to render a verdict of guilty on both counts. Thank you.
Thank you. Let's make it their opening statement now.
Thank you, Your Honor. Your Honor, the wrong person sits in the defendant's chair tonight. This is a case about jumping to conclusions, hasty rushes to judgment, and false presumptions. Prosecution will not clear its burden of overcoming the reasonable doubt that will be presented tonight. Prosecution has charged my client with murder. This charge will fail for multiple reasons. First is that the victim, Jason Johnson, died of alcohol and not Adderall. The second, there is not sufficient proof that my client, Mr. Concha, provided the victim